Welcome, then, this afternoon to our panel on conscience in the public square. Before we get started, I have to tell you a couple of things. I have to make a couple of announcements. The first announcement is that you must turn off your cell phone. Your cellular telephone must be turned off because this is being taped. And so if your cell phone goes off in the middle of the session, the cameraman will pan to you and as you awkwardly fumble, and then, so don't do that. And the other thing I'm supposed to announce is that we have allotted 45 minutes of networking time at the end of this session for attendees to engage with panelists and other convention participants. All right, so the issue for today's panel.
That's network.
Is that Q&A? No, I don't think so.
No. So the issue for today's panel is about religious exemptions. And so more or less, here's the issue that we'll be talking about. When can a religious individual or religious institution insist upon an exemption from a general law? I mean, there are lots of permutations and tricky specifics, but that's generally the issue. So if you have an employer, or a general law that says employers have to provide contraceptive coverage to employees, or you have a law that says adoption providers have to provide services to all couples, including same-sex couples, or you have a requirement that says that pharmacists have to fill prescriptions for whoever comes into the pharmacy for whatever prescription it is, or if you have a restriction, a general restriction that says nobody can use marijuana or a hallucinogenic tea or kill a bald eagle. The question is, when can a religious individual or religious institution demand an exemption from one of those general laws? Under the Constitution, under a statute, under a state constitution, et cetera. When can a religious person say, hey, this obligation, this government law violates my conscience, I cannot follow it, I should be exempt from it? I think it's an issue that pits claims of religious conscience of individuals and autonomy of religious institutions on the one hand against the various goods that government seeks to promote on the other hand, and it's a very difficult, tricky, hard, and interesting issue. And luckily for us, we have about the four best people we could possibly have today here on the panel to discuss this set of issues. And I'm going to introduce you to them, but only very, very briefly because you have your book there, which tells you all the details. So I'm just going to quickly introduce you here. To our far, far left there is Melissa Rogers, who, if you check her bio, actually has like 12 different positions. Just highlight that she's the director of the Center for Religion and Public Affairs at Wake Forest University Divinity School and a non-resident senior fellow of governance studies at the Brookings Institution. On her right is Louise Melling, who is the Deputy Legal Director and the Director of the Center for Liberty at the American Civil Liberties Union. You've heard of that, right? Next to her is Tom Berg, the James L. Oberstar Professor of Law and Public Policy at the University of St. Thomas School of Law. And then finally to my direct left is Bill Marshall, who is the William Rand Keenan Jr. Distinguished Professor of Law and Public Policy. Distinguished Professor of Law, not Public Policy. You couldn't possibly understand. You don't understand that at all, is your problem. At the University of North Carolina School of Law. And so this is the panel that is going to help us work through these issues. And I'm going to start with Bill. And I'm just going to ask you to tell us about the evolution over the past, say, 30 or 40 years of progressive views on these kinds of exemptions. And on the way in doing that, please tell us a little bit, about the basic issues, the basic legal provisions, the key cases, so that we all kind of are on the same page as we go forward in the discussion.
Okay, well, we can subtitle my talk, Was Justice Scalia Oppression Progressive? That would be one, or What Goes Around Comes Around. It would be another way to summarize the issue here. But I want to talk about this issue of exemptions, because exemptions really was a big liberal idea, a big progressive idea for a long time. In the conscientious objector cases, they were statutory cases, but liberals and progressives argued for very strong conscientious objection provisions for those who wanted to oppose the draft as a statutory matter. When free exercise cases came to the Supreme Court, the key case was Sherbert versus Werner, an iconic case of the Warren Court decided by Justice Brennan, who said that religious objectors to neutral laws have a free exercise right to have those laws declared unconstitutional with respect to them, that is, to get an exemption from those laws, absent a compelling interest on behalf of the state. So a very, very rigorous constitutional test. It was never, in fact, interpreted that rigorously, but at least on the books, that was the test, the compelling interest test. Sherbert was followed up by Yoder, the famous Amish case, allowing the Amish to have exemption from compulsory school requirements after a certain grade. Again, a decision celebrated primarily by progressives, as was Sherbert. There were lots of good reasons supporting why you might want to have exemptions on religious basis from laws. One was just this notion of individual liberty. Second, a notion of conscience. We didn't want Mrs. Sherbert conscience violated by being forced to work on a day that was for her a day of rest. Opposition to government orthodoxy. Was it appropriate for the majority to be able to regulate the religious beliefs, or at least affect the religious beliefs of minorities? And much more sophisticated pluralism, the idea that it was good to have a lot of intermediate communities with their own sense of ideas as a check upon the orthodoxy and the power of the larger government. So these were all very strong reasons in favor of the exemption. Probably conscience and the protection of individual liberty being the strongest. And they captured the imagination of progressives for many years, and progressives in general supported Sherbert and argued, if anything, that it should be more rigorously enforced. Then came Smith, Employment Division versus Smith, a case in which Sherbert was put to the test. At issue there was whether or not members of a Native American religion should be exempted from anti-peyote requirements. And Justice Scalia, in a 5-4 decision, said no, there was no right for a free exercise exemption against a neutral law of general applicability. That is a term of art. There's a lot not to like about the Smith opinion. One was it overreached. The actual issue of whether Sherbert should be overruled or whether the test in Sherbert should be overruled was not before the court. They reached it anyway. They've done that recently in a finance case. I'm not sure the name of it. It disingenuously distinguished prior cases. It distinguished Sherbert, saying what Sherbert was all about was individual assessment case. And when you had the government making individual assessments, it had to include religion if it had to include others. There's nothing in Sherbert which suggests that Sherbert was on that basis, was decided on that basis. Distinguished Yoder as being a, quote, I'm not making this up, hybrid right, the first beefalo in constitutional law. Sounds a lot like penumbras to me, but it was a Justice Scalia opinion saying that if somehow you had a right, a First Amendment free exercise right combined with some other right, in this case the right to direct the upbringing of your children, see Pierce versus Society of Sisters, then maybe then you could get the full free exercise benefit. But the significant attack on it was actually its results. It got rid of the compelling state interest test, and progressives were outraged. In fact, conservatives were outraged. And one of the most amazing things, this is for those of you who don't remember 1990, a fascinating thing happened. The left and the right combined on an issue. Go figure. And RFRA was, the Religious Freedom Restoration Act was passed with broad support coming from the very left and the very right. The Christian Legal Society to the ACLU all supported a statutory attempt to try to recreate the compelling interest test, apply it statutorily. You know what happened to RFRA in Bernie. That case was part of the application of RFRA to the states was struck down as a violation of Section 5 of the 14th Amendment, but I'm not going to go in that direction. Very few people, in fact, I think there were 8 people who supported the Smith decision. 5 members of the Supreme Court and 3 other people, including myself, thought that it was actually a correct decision. My reason at the time was there was a problem with this free exercise exemption. It seemed to privilege some kinds of ideology, like religious ideology, over non-religious ideology. There was a case coming from Sherbert in which there was a Jehovah's Witness who objected to working in an armaments factory. The examination of him didn't indicate whether the reason why he didn't want to work in the armaments factory was religious or philosophical or whatever. The court construed it to be religious and said, you know, because it's a religious claim, he gets the exemption. But if it was exactly the same deeply felt philosophical claim, he would not. And at least some of us argued that that seemed to question other First Amendment values. Now, the answer to that might have been to draw conscientious objection more broadly and include non-religious believers as well as religious believers. That's possible. But if, and this is where I'm going to end my comments for the moment, but if you do that, if you go back to this question of conscientious objection, you got to accept the fact that it's going to apply to laws that you like as much as it does to laws that you don't like or don't even care about. And the question I think progressives have to deal with are these values that I talked about earlier, conscience, pluralism, and protecting exemptions, how do they play in the constitutional balance with some of the questions that Jay was talking about and we're going to talk about later on in the panel with respect to what happens when you're dealing with laws that you might have a greater affinity with. Okay, thank you.
Thank you. Who were the other two? The two other people who didn't?
Like Smith, yes.
Mark touched on, I think.
The litigators, maybe.
Mark touched on, and there was
It's another guy.
Yeah, it was one other guy who's working in a restaurant somewhere now.
Okay, so now let's turn to Louise, if I can. You are the Deputy Legal Director for the nation's most prominent progressive litigation organization. So what are your current views, or your organization's views, if you like, on these issues? Maybe bringing us up to date to the modern, to today, and the issues that you're dealing with on a daily basis.
Sure, thanks. So this is a big issue for us at the ACLU, and we are one of the organizations that cares deeply about both sides of the equation because we're such a multi-issue organization. So we have robust defense of free exercise and religious rights, and then we have robust defense of reproductive rights, women's rights, and LGBT rights, which is the modern iteration of the conflict between religion and anti-discrimination principles. And the issue is, alive and well and in our faces, sort of, for tackling what our positions are in many instances, ranging from the police officer who doesn't want to protect the abortion clinic to the ER nurse who doesn't want to do the emergency abortion to all the institutions that don't want to comply with the contraceptive mandate, and on and on and on, and so it goes. And these issues are, we have positions, and then we can sort of contest all the nuances just so that you know that nothing will be quite as bright in the actual office as what I report here to you. But our basic principle has been quite consistent over time, which is always lovely. And here it is. Here's like a sort of more formal presentation, then I'll sort of unpack it. First of all, we don't think the Constitution usually dictates the answer, right? There are maybe some over on the ministerial exception side, but in general, the Constitution is neither requiring nor prohibiting exemptions. So then you get to a question almost of how do you balance the I don't mean balance in a legal sense. I mean, how do you think about the competing claims of religion, the competing claims of anti-discrimination principles? And so our general norm is that the law should not exempt institutions. And we concentrate a lot on the difference between institutions versus individuals. From generally applicable anti-discrimination laws, when the practices that are subject to such laws are secular in nature, I left from Colorado this morning, I'm having trouble with language, are secular in nature, and allowing an exemption would result in the imposition of religious tenets on others in civil society. So that's just really a way of saying when the institution is offering a secular service, opening its doors up to the public, it has to play by public rules. When an institution isn't, when an institution is primarily pervasively, its prime purpose is to inculcate religion, it's hiring and serving people of the faith, it could have an exemption because you're not then imposing on other people. That religious freedom is definitely your right to believe, it is not your right to impose on others. And in particular, in the instance of an institution, the thing we often say about in the office is when St. Vincent's was still around in New York. If I were in the ambulance on the way going into St. Vincent's, I wasn't thinking I was going to have a particular religious prescription. I was being taken to an ER, to a public facility that opens its doors. It's certainly true for us that we understand well why there's resistance. And so I just want to talk about what goes on sort of in these modern debates. I spend a fair amount of my time sort of trying to convince journalists or editorial boards to be on board with us as we face, for example, the contraceptive equity measures, as we face these questions about adoption agencies, whether adoption agencies then get an exemption from any kind of anti-discrimination principle in their state, as with Illinois. And there's often sort of a resistance, right? So I'm going to pick marriage. When a law passes and says that marriage extends to same-sex couples, and people will say there are proposals for exemptions that would extend to anybody who objects, including photographers, inns, and people who would be performing, who would be in the clerk's office. We agree that within the church, the requirement doesn't extend. And people often say, well, but those are legitimate objections, and they are legitimate objections. I mean, legitimate as in heartfelt. They are often deeply felt. But one of the things, that we sort of ask ourselves, at least looking back in history and where the arc of justice goes, is after Loving, would we say that the inn should have been able to turn away the same-sex, the interracial couple because of religious objections? Should the photographer have been able to sort of promote his or her services, and then when the photographer learned that the couple was interracial, say, no, I have an objection? Should the couple not have been able to go be served at Piggy Park, a drive-in in the South that challenged integration laws based on religious objections? These are real. I mean, it is not as if there weren't the same kind of religious objections, deeply felt religious objections to integration of the races. And I do often find that when you say that to people, people say, well, no, of course the inn should have, accepted the couple, and then it's harder to understand what the sort of difference is. And two things that, arise in these conversations often are, well, if there's another place people could go, this comes up in the context of pharmacies, for example, if there's another place that somebody could go and still get service, shouldn't there be an exemption? And you could have a rule that you have to provide if there's no other alternative. And then the other question is, well, do you really want to go to the pharmacy that doesn't want to treat you, or do you really want to go to the inn that doesn't like you? And as to those, I just go back again. Like, we don't say, like I live in New York, we don't say, oh, if you, in the context of race, if Dwayne Reed doesn't want to serve you, you could go to CVS. There's a CVS like 3 steps away. That's not the principle, right? Even if that's no matter what, you don't say when you open your doors that way that you can turn people away as an institution, in our view. And the question about, well, what about the fact that people don't want to serve you? You wouldn't want to go there. I just go back again. That's part of changing society. That's part of moving institutions along. And what's behind all that, I think, is both the anti-discrimination norms that we believe in, that we're so deeply committed to. If you want to think of it in a legal sense, you can think of it as a compelling state interest. One of the reasons why we struggle sort of with totally just embracing that, say in the context of Religious Liberty Restorations Act or other measures, is that the Supreme Court today, for example, doesn't recognize that there's a compelling state interest in the equality of same-sex, of lesbian and gay people, for example. We see that as as a compelling state interest, or we see that as a sufficient norm to override. And so for us, it is really about making sure you can advance those interests and respect this very, very serious dignitary issues that are in play when you have institutions basically close the door in your face and turn you away.
Thank you very much. This issue of institutional rights versus individual rights is something that we'll certainly come back to later on in the conversation. Right now, I'd like to turn to Tom, who, as I understand it, believes that it is, in fact, possible to support progressive positions on these underlying religion issues, but at the same time support serious exemptions and accommodations for religious institutions. Am I right about that? And if so, why?
You are right about that, Jay. Surprisingly enough, we talked a little bit beforehand. So I'm going to give
three reasons why progressives should be open to meaningful religious accommodations or conscience accommodations. And let me just say quickly at the outset that I speak as someone who supports same-sex marriage, has publicly done so. I speak as someone who supports the Affordable Care Act and worked on trying to defend it against charges that it would fund abortions. And I support a lot of other quote-unquote progressive goals. I won't, I guess maybe we need to define that term at some point. But I say that not to get street cred here or suite cred if we're sitting in a suite, but because I have a little bit of a concern that this debate has gotten to the point where there is an assumption that your position on religious liberty equates with your position on the underlying policy issue. And so I think, it doesn't for me, and in many cases, and it doesn't have to. And in fact, religious liberty ought not to be that. That's almost the opposite of religious liberty, to have it track your position on the underlying issue. But I'm afraid that we're at the point where that needs to be said before someone talks about this. So I wanted to do that. The first two arguments are arguments of principle, and the third is a pragmatic argument. So first, progressives and liberals and civil libertarians have, as Bill said, historically supported religious liberty, strong religious liberty from non-mainstream views. That's why they supported exemptions under the Sherbert regime. That's why they mostly opposed the Smith decision that ended exemptions. That's why they mostly supported the Religious Freedom Restoration Act. When a conscientious belief conflicts with the law, that is almost always a non-mainstream view, almost always a minority belief. If you want to protect minority religions from the law and protect their ability to practice their faith, you are going to have exemptions from the law, because we live in a democratic society and the laws reflect majority rather than minority values, with some complications in that statement, but for the most part, it's true. And this is true even if the people who hold the belief that clashes with the law are part of a larger mainstream body. That's the case, I think, for example, with traditionalist Catholics who oppose contraception, right? They're a definite minority within the Catholic Church. The Catholic Church is a larger body, but that doesn't make them a sort of dominant majority in society. Progressives historically supported religious liberty for a number of reasons that Bill has stated, but I think a lot of them boil down to, why religion compared with all the other things that you might support? And they supported it, though, because they believe that one's individual commitment to religion and one's participation in a religious community are very central features of people's identity. They are major, pervasive commitments of people. And so to protect the autonomy of human beings means protecting religion, among other things, but religion is one of the features that calls for protection. Because religion is central to people's identity, they suffer when they're forced to contravene their tenets. And the people running organizations suffer when they are forced to contravene the tenets of change the tenets of the organization. Progressives over the years have empathized with that view, even when they didn't empathize with the actual position of the group. It wasn't like progressives were all in favor of peyote smoking, maybe just 75% or something. But no, you support the people and their identity, not the particular behavior. And so I want to endorse Bill's point that taking religious liberty seriously means taking it seriously for laws you don't like. Now, it's possible for legislation with exemptions to reflect empathy for both sides. It's actually possible. There are complications in it, but it's possible to have a regime about same-sex marriage, for example, that would reflect empathy for both sides. You can have same-sex marriage and you can have some exemptions. I actually think there are parallels between the claims of the two groups. I'm not the only person to say this. Bill Eskridge has said this, and others have, and won't claim to agree with everybody on every point, but both same-sex couples and the religious objectors claim that their conduct stems from commitments that are central to their identity, whether it's love and fidelity to a life partner or faithfulness to the moral norms of God. They also claim that they ought to be able to live out these commitments not simply in some private insular space, the bedroom or the worship space, but they ought to be able to live it out in a sort of public way, either through participation in the public social institution of marriage, or by being able to engage in the kind of activities that Louise referred to as public activities in the public sphere. Helping others, educating others, giving health care to others, helping immigrants, helping couples adopt. So I think there are actually a lot of parallels, and if we could see some parallels between the two claims, it might help us towards resolving these kinds of questions. The second reason that I give is that religious conscience exemptions, as Louise said, regularly raise the question about whether the core of religious freedom extends beyond the worship space into these service activities and organizations. A common way to limit religious freedom is what she suggested, is that you have the right to worship, you have the right to be in the private place, you don't have the right to take it out into the public sphere. I think progressives should be really leery and even disturbed about that view. And the contraception mandate, which has a lot of aspects to it, raises that. You know, under the original exemption proposed by HHS, an entity was ineligible for exemption if it employed persons outside of its faith, okay, or if it even served persons outside of the faith. Even if it served persons outside of the faith, it had to provide contraception to its employees. Or if it even served people within its faith primarily, but didn't preach, but was mostly doing works of mercy and service for people within the faith. Now that is an extraordinarily broad set of extraordinarily restrictive set of limits on an exemption, and it would have fallen on, and may still, if we don't know what's going to come out of the process, on organizations whose work benefits the needy in society and for many people constitutes the very core of religious faith. Those are the things that progressives often say they value most in religious faith. And I am going to give as one example of that President Obama, who's in his speech in 2008 during the campaign recounted his realization, quote, this is part of his religious development. While I could sit in church and pray all I want, I wouldn't be fulfilling God's will unless I went out and did the Lord's work. There are millions of Americans who share a similar view of their faith who feel they have an obligation to help others. While these groups are often made up of folks who come together around a common faith, they're usually working to help people of all faiths or of no faith at all. The people that the president commended so highly as being at the core of religious faith in that passage are the ones who were excluded per se from protection under the original mandate. I think that should be troubling to progressives. My third reason for arguing for accommodations is a pragmatic one. It's easier to enact a law, including for our purposes here, a progressive law, if the legislature makes accommodation for objectors. And the primary recent example is the question of same-sex marriage, as has been brought up here already, whether to allow refusals of service by religious objectors, the college with married student housing, Catholic Charities adoption agency, the wedding photographer. If you if you just give an exemption to clergy and houses of worship officiating in a marriage, you haven't touched the vast, the largest percentage of the kinds of questions that are going to come up. There actually probably aren't a huge number of cases, but in terms of the percentage of cases that will come up, the clergy and the officiating at the house of worship is a minuscule percentage of it. Here's what's happened in the states. As of March 2012, same-sex marriage with that minimal clergy exemption had been introduced in 9 states and the District of Columbia and failed each time. Maine's same-sex marriage law did the same thing. It protected nothing more than clergy and doctrine, and it was overturned by the voters in a referendum. By contrast, in New York and Connecticut and Washington, legislatures first failed to pass same-sex marriage with the narrow exemption, the clergy only. And then a few months later, they came back and broadened the exemptions and passed it. In New York, it was a combination of moderate Republicans and Governor Cuomo who got on board on provisions protecting other organizations in connection with the celebration of a wedding and clarifying that even outside the direct context of the wedding, religious nonprofits could still make decisions consistent with their religious principles. Same-sex marriage passed in New York, and these exemptions are widely acknowledged to have made the difference. New York Times observed that the provisions, quote, helped pull the legislation over the finish line. The Times headline for that story read, "Exemptions were the key to the vote on gay marriage." Other contexts may be more complicated, but in many cases it's much easier to pass legislation if you make room for those with sincere objections. And I'll stop there.
You've got street cred with me. I'd like to now go to Melissa. Hi.
Hi there.
Who you're known as staking out very balanced, I think, positions here on these issues. We all know you in the law and religion community as doing that. And so I'm wondering now, having heard kind of a very pro-exemption case from Tom and a less enthusiastic exemption case from Louise, where do you see yourself on that spectrum? Are there things that you've heard that you disagree with? And while you talk about your position, perhaps if you'd like to, you could broaden the discussion out a bit to involve cases where the government is actually funding an activity, school voucher, or is funding an adoption agency or something like that. When the government does that, can it attach strings, conditions to the funding? Maybe you could talk about that as well.
Okay, thanks. Well, by way of background, let me just say that while Bill was telling old stories, I'll tell a couple myself. We go way back. I worked for the Baptist Joint Committee for Religious Liberty when, in the immediate aftermath of the adoption of the Religious Freedom Restoration Act, and also with the push for the enactment of what is a successor legislation known as the Religious Land Use and Institutionalized Persons Act, otherwise known as RLUIPA. And so the Baptist Joint Committee for Religious Liberty is an entity that prides itself on very strong defense of both the establishment and the free exercise clause as matters of conscience, that the government shouldn't meddle in religion, either to promote faith or to interfere with faith without a compelling reason for doing so. And so that my own views are resound with that organization's views. And we had the privilege of leading the RFRA and RLUIPA coalitions, and the meetings there were quite interesting when you do have the ACLU and all the way to Pat Robertson's ACLJ in the same room. It is never boring. So just to set a backdrop, I will say that. And so I think the government should have a very heavy burden when it does use its coercive power to interfere with religious exercise, even if it's doing so unintentionally. And so, you know, I think a lot of my views on that score would stack up with Tom's views. But I also want to say two things that I think take the conversation in somewhat different directions. One has to do with this issue of government funding. When we dealt with the RFRA legislation, for example, in the early 1990s, the Supreme Court had not yet liberalized its rules on government funding for religious institutions and individuals. It made some moves in that direction, but a lot of that movement really happened after RFRA passed, where you had basically the Supreme Court moving from a position where it was very careful about scrutinizing the funding that went to religious entities for some secular purpose, and then little by little moving to a much more relaxed position, if you will, about government funding flowing to religious schools, religious social service providers, and the like, whether it was in direct aid through vouchers or direct aid through things like grants and contracts for social services. And so one of the interesting dynamics in this discussion that has come up after there was this great unity among progressives and conservatives about free exercise is this issue of government funding. And unfortunately, what it has done is driven a great wedge between the old RFRA coalition, because on the one side there are folks who believe that when federal funding goes in the form of a grant or a contract to a religious social service provider, for example, that they should have the same rights to discriminate on the basis of religion in hiring and firing with respect to a government-funded position as they should have with respect to a privately funded position. And that kind of issue has divided the old RFRA coalition. And as more and more money flows to more types of religious organizations, these issues get raised in various ways. I've already mentioned one in terms of whether a religious organization should be able to hire and fire on the basis of religion with respect to government-funded position. My own basic take on this is that when a religious organization is funding a position with its own funds, then it should be allowed to make decisions on the basis of religion. But when it is receiving a government grant or contract, it should not be permitted to make decisions on the basis of faith, in effect telling people that they are the wrong religion for a taxpayer-funded position, when the mission of that program by necessity has to be centered not around agreement about religious issues with the government, because that wouldn't be appropriate under the Establishment Clause, but rather agreement on a social service mission that the government and the religious organization can both affirm. And so I think they can have mission hiring based on that sweet spot of agreement among the religious organization and the government, between the religious organization and the government, but I think it's inappropriate for religious organizations to make decisions on the basis of religion with respect to government-funded positions. Similarly, I think that when you have, for example, a government grant or contract that's given to religious and non-religious organizations for providing adoption and foster care services, and they decide that there should not be a condition on that grant is that there should not be discrimination on the basis in the adoption and foster care services. There should not be discrimination on the basis of sexual orientation or the fact that a same-sex couple is married. Then I think it's appropriate for the locality or the city, whoever it is, whatever governmental body, to say we're not going to make exemptions from the conditions that follow this grant, whether they follow the grant to a religious or a secular organization. I think if that is problematic for a religious organization, then I think the religious organization should say, I will not accept that grant or contract. I will instead provide privately funded services rather than take the government grant and have to live by conditions that I think appropriately go along with the grant but do not mesh with the religious group's understanding of its mission and its values. And of course, as we know, most religious groups provide social services on their own dime. It's only the few that get a government grant or contract to do so. So that's certainly not saying to religious organizations that they have to, be ostracized from society. Not at all. The work of all religious groups, in my view, on these issues are valued, but there has to be, I think, when the government decides to give out taxpayer money in the form of a grant or contract, I don't think it would be appropriate for the religious organization to insist on an exemption from that kind of anti-discrimination condition. Another issue that I just want to mention is the idea of access to care, and I think this comes up in the healthcare context most prominently. But I think that when the government provides exemptions to religious entities and institutions due to their conscientious objection to providing certain lawful healthcare services, it must also ensure that the people who need those services can get them without substantial difficulty. And I think one unfortunate fact that we have to look at here is the effect that giving exemptions to institutions have. When an exemption is given to an institution like a hospital, it has the potential to affect many more patients than would be the case if an exemption was given to an individual doctor. Because when it's given to an institution, then even a willing provider working within that institution cannot provide the care. And so I'm not saying that that's a reason not to grant an exemption, but I am saying that's a reason to think about how we ensure that there is access to service and hopefully protection of the conscientious objection as well. Let me just close at this point by saying that having said all that, I share Tom's concern about this issue of saying to religious organizations, if you do anything that secular society deems to be public in any way, and this came up in the Hosanna Tabor ministerial exception case, like if you offer services that the government considers to be public, that it might offer itself, then you can't have, some would argue that you can't have the benefit of the ministerial exception, which allows religious communities to make decisions about who are their ministers free from any government oversight. I think that that's troubling to me. It makes sense to me when you're saying when you're accepting government funding that there are rules that come along with the funding, and don't take the funding if you can't play by those rules. But I'm concerned about situations, for example, when religious communities would be providing services that they fund totally with their own money, but yet they're told they're doing something in public that the government considers to have some public aspect, even though it's not government funded. And thus, they have to give up any distinctive quality about their faith. One of the reasons that's troubling to me is I believe the First Amendment says that religion can never be government endorsed or advanced. But yet, religion has a vital role to play in the public square. It belongs in the public square, playing its role, speaking out about what it believes, along with all kinds of other communities. And to the extent that we say to religious communities, if you do anything that we think is public, then you have to shed your distinctiveness, I think that begins to undermine and even give, let me say it this way, I think it gives credence to the false notion that the First Amendment kicks religion out of public life, when it doesn't. In my view, the First Amendment says the government can't advance religion, it can't fund religion, it can't promote religion, but it must allow religion to play a role in our community that in some ways is public. So that's a bit of a summary of where I come out.
Thank you. Let me just let everybody know that in about 12 minutes probably or so, we'll open, could go over, could be 13. But I'm going to open it up for questions. So start thinking about, the kinds of questions you might want to ask now. Juicy, delicious questions for the panel, and we'll get back to you in a moment. For a second, I might just ask Tom, because I know you differ a little bit on this funding issue from Melissa, or at least I think you do. If you want to comment just for a couple of minutes on that question about whether the government can put conditions upon anti-discrimination, for example, conditions upon funding religious institutions.
To some extent, it can, and the case law is really clear about that. But let me start off by noting that Sherbert versus Werner was a funding case. This is Sherbert, the Seventh-day Adventist, who wanted to worship on Saturday rather than Sunday, wanted unemployment benefits, and the state denied her unemployment benefits and argued that there was no burden on her religion because this is just a benefit. This is government funding, and when you take government funding, you take the bitter with the sweet. You take whatever the government wants to give you. Justice Brennan was no fan of the bitter with the sweet doctrine. He said, and he articulated in Sherbert is one of the great unconstitutional conditions cases. Another doctrine that progressives used to believe in very strongly. And I don't know, I think there's probably more ambivalence about the unconstitutional conditions doctrine now. But that doctrine reflects the idea that government can coerce people or pressure people the way it did Adele Sherbert, the Seventh-day Adventist, by withholding funding as well as by fining people or directly penalizing them. Now, with that said, funding is more complicated than regulation, and I do think that Melissa is right to point to the difference between specific conditions in a grant and broader conditions on the organization that receives a grant or receives some kind of funding. Unfortunately, an awful lot of government funding programs don't respect that distinction. If you get any government money anywhere in your organization, the non-discrimination provisions extend throughout the whole thing, and I wonder whether she or others think that that's okay. And the second thing I'd say is that although there's not much in the way of constitutional arguments against withdrawal, against conditions on funding are really hard to make, mostly due to the work, by the way, of conservatives on the Supreme Court, not due to the work of liberals on the Supreme Court. But that's a different question from whether the government ought, as a policy matter, as a matter of prudence or good sense, ought to impose a condition. We could assume that Catholic Charities, maybe, if to the extent it was publicly funded in Massachusetts, although it was not just a case about public funding, it was actually about their ability to have a license to do the work at all. But to the extent that they were publicly funded, let's assume that they didn't have a constitutional challenge to the condition that they serve same-sex couples equally. There's still a policy question about whether it's a good idea for the state of Massachusetts to deal with an organization that has done excellent work in this area for years, especially with special needs children that are hard to place, and effectively cut them out when there are plenty of alternative providers. Now, I'm coming to the alternative provider point, and I really think it is very important in a lot of these questions. It's a way to manage these conflicts and for both sides to live together. And I understand that I recognize that there are dignitary harms to being denied service. I think there are dignitary harms to being booted out of a government program that you've been working in for years too. And so I have a little bit of trouble assessing exactly how to gauge dignitary harms. I think we have more room to come to accommodation of both sides if we look at concrete effects on ability to get services. If there is another wedding photographer on the next line in the phone book, if there are multiple other providers to provide adoptions, can't we make room for conscience in that situation?
Well, why don't we pick up right there and talk about this access issue and this effect on third-party issue. I like to think of it in the context of the pharmacy, the issue, the pharmacy perspective. So someone comes in to a pharmacy for contraception or for, say, the morning after pill or something like that, and the pharmacist is a devout, say, a devout Catholic and doesn't want to fill the prescription, says that filling that prescription will violate his or her deepest religious beliefs. What do we do in that situation? So imagine now, this is sort of law school-y, hypothetically stuff, but maybe it'll get us talking, about some specifics. Imagine now that there's another pharmacist who's at the same pharmacy who'll fill it, right? Hypothetical number 2 is there's another pharmacy in town that'll fill it. And then number 3 is there's a pharmacy that's 10 miles away, and number 4 is it's 50 miles away, and so on and so forth. And then we throw in how maybe the person doesn't have a car, and we permute it 100 different ways. But let's just take those 4. Pharmacy, another pharmacist will fill it, another pharmacy in town will fill it, 10 miles away, 50 miles away. Louise, I took it from your comments earlier that maybe I'm wrong, that you would not go for any of these, or am I wrong?
Wrong.
Wrong.
I'm always excited. No, so we have said that a pharmacy, if there's an obligation, for example, can I just step back for 1 second, which is when we talk about this public-private issue, we are not coming in. The stance I advocated here was not that institutions could not maintain a religious identity. It is in those particular instances where there's almost like, in essence, a compelling state interest or one of those societal mandates that you say that an exemption isn't appropriate. The Catholic hospitals, 1 in 5 beds in America today are in Catholic hospitals, even if they are required to provide contraceptive coverage to their employees who are people of all different faiths. They will still be able to preach to you, to have services, to engage in other things. So this goes back to institutions versus individuals and context. So we have said that institutions, your pharmacy, your business, you're opening your door to the public, you're serving people to the public, you're probably hiring people, your primary purpose is not to inculcate your religion, your primary purpose is to engage in this very quintessential secular business service. You as a pharmacy do not, we advocate against exemptions for pharmacies in those instances. Pharmacists, if there's another pharmacist who can assist, we have traditionally said that you can accommodate the pharmacist. And again, when you think about the pharmacy, certainly we've talked to clients. We represent people who responded to ads for the destination wedding. And they were going along in the wedding planning, and then the institution discovered that it was a same-sex couple and sends an email saying, oh, not so much, and sometimes much harsher than that. That is a tremendous harm, and I don't disagree that there's a harm to the owner, but I feel that the harm of the owner has been articulated well by Tom, and I'd like to just put out the other side. There's we were also called by a woman who went to go buy a wedding dress. She's at a store. It's covered by the Public Accommodations Law. It has a provision against discrimination again based on sexual orientation. She references, as she's trying on her dress and she's prepared to buy, that her partner in the wedding is a woman, and she is told that she will not be allowed to buy the dress, and she is sent away. Those are real harms, and they are what I sometimes talk about. If we care about equality and we care about anti-discrimination principles, granting exemptions to institutions in these fashions that are opening their doors and you don't really have warning is sort of, as I say, making equality sort of look like Swiss cheese. It's equality with a bunch of holes in it, and that's what's so, deep. That's what's deeply troubling for us and why we advocate in these instances against the exemptions.
Bill or Melissa, do you want to weigh in on either of you on this access issue here?
Do you want to go?
Only I just want to, just because Alan said don't let the panel get too quiet, throw a hypothetical and that might test people's intuitions the other way. Let's assume that the pharmacist is being asked to provide a lethal cocktail for an execution and doesn't want to do that.
Yeah.
Is that a different case?
Yeah.
Why?
Anybody want to answer that?
Yeah, I think that's really helpful what Bill just did, because in the contraception mandate, for example, I've been trying to think about, well, what if the government required employers to, including pacifist religious employers, to pay for or provide or endorse military training for their employees and try to run it through there and see if I'm being consistent. So I think that's a really helpful discipline. On the pharmacist question, I'm afraid I'm not going to remember each and every of the 4 prongs of your test. But I mean, I would tend to, let me say, I would tend to go by access and what interferes in a substantial way with access for the patient. If it can be filled by another pharmacist, I think please, do that. And this would be covered by something also like Title VII of the 1964 Civil Rights Act that says that employers have to accommodate their employers' religious objections if they can do so without undue hardship. Unfortunately, that standard has not got a whole lot of teeth courtesy of the Supreme Court, but it is out there. And I think if another pharmacist can fill the prescription, that's good. If they can walk across, right next door there's a pharmacy and get it filled, that would also be good. But I also think that Louise raises an important point when she talks about people being caught without warning, without any notice that these things are going to happen. One of the things that I favor in this area is laws that would force information and force disclosures on the internet and other ways, to the degree that we have conscientious objectors, especially to the degree that it would impair access to any degree. People should have some warning, and they should know right from the get-go about places that bill themselves as certain kinds of places, or pharmacists that have certain kind of objections should have to let their employers know that. They should be able to staff around it. The patient should not be the patient should never be proselytized. The patient has a conscience. The patient conscience should be honored. They should not be lectured. Anything like this, we have to look at both sides. So I would be, I think 50 miles is too far. And
36?
Yeah, probably too far. Across the street, not too far. But I think that we do have to work on some of these disclosure options. We have to make it clear what is conscientious objection and what is actually blocking access and running roughshod over the conscience rights of the patient. I have heard in certain contexts that a pharmacist who objects to certain prescriptions would tear up the prescription. Well, that's clearly not a conscience issue. That is blocking access. And that's different. And so I think we have to think about those things differently.
Can I just ask one question? Would you have
Sure.
the same position with Piggy Park, which is the religious Piggy Park, a drive-in restaurant in the South, goes to the Supreme Court. Owners have a religious objection to the integration of the races. Early 60s. I'm sure there's another restaurant in town.
I'm glad you
And what do you
raised
do? What does notice mean? Notice means a sign that says, "No blacks here because of my religion."
Yeah,
so why is that?
Thank you
why
for-
is that
yeah.
different? That's what I really
Right.
struggle with.
I appreciate
in
that.
drives
No,
to
I would
this.
not. I would not say that is the same case. And I think that, first of all, race is different. And we are talking about situations where you would talking about service provision, where the person would deny a particular. They say, I'm not going to fill any Plan B prescriptions for anybody, no matter who they are. As opposed to, I'm not going to serve this person because of an immutable characteristic of who they are, and I think those are different.
Yeah, the gay rights situation is harder on that.
Yes.
So can I follow up and answer that too? Because I think it is a very important question. I think the two are different. That does not mean that discrimination against gay people is not a serious problem, but it also means that both things can be serious problems, and yet they can be at different levels or different ways. I think first of all, it's worth noting what the position that equates racial discrimination with discrimination against gay couples would mean. It doesn't just mean that Piggy Park can't do it. It doesn't just mean that the Inn can't do it. It means that under the principle of Bob Jones versus United States, every single religious institution in America, perhaps other than churches, should have its tax exemption stripped if it engages in any kind of policy about same-sex activity based on its religious beliefs. It would mean, I think, probably, that a fundamentalist religious school could not forbid a teacher could not refuse to hire a teacher who's engaged in a gay relationship. I think you'd have only an expressive association claim, and race is probably a compelling interest. If sexual orientation is exactly like race in all respects, the fundamentalist school should have to hire an openly gay teacher. The consequences of equating the two go far beyond the commercial sphere. We have consigned racism to as small a private sphere as we possibly can. We did that for a variety of reasons. We did that because we had, because it's wrong, and but also because we had, in our particular American context, a long-term history of pervasive oppression that had corrupted our constitutional order. And do we want to treat every situation of wrongful discrimination that we decide is wrongful discrimination just like that? If we do, then we're going to have an awful lot of social conflict going forward.
Terrific. At this point, I'd like to open the discussion up for questions and answers. A couple things. First of all, we've got microphones, I think. And so please, before you ask your question, wait until you have a microphone. And also try to, because we have the limited amount of time, try to keep your questions kind of short and questiony. Okay, so
Question-ish.
all right, sir, over here.
So I have a question about what I think is a unique circumstance of the Catholic Church, which is, unlike most of these cases where you have, say, an anti-gay individual wearing an anti-gay T-shirt and they're asserting their own right, what you have in the Catholic Church is you essentially have a situation where a radical sect of the Catholic Church, which happens to control the bishopric of that church, holds a view that, by one estimate, 98% of the church's members do not hold on birth control. And so given that situation, if you have a Catholic hospital, it makes sense to me that, like, if you have an individual doctor or if you have some sort of institutional consensus that there is a sincerely held religious belief that could potentially trigger a religious right. But when you have a hospital where all of the people doing the dispensing do not have a sincerely held belief that is relevant, how does that go to the sincerity for the purpose of the religious exercise doctrine?
Is that for me or anyone? I would say, I guess I'd say two things. First of all, many of the decision makers here are not the bishops. The bishops have been out front making their statements about religious liberty and so on. But Catholic Charities objected to the original mandate, and the bishops don't control what the heads of Catholic Charities do, or they don't control. They have certainly failed in controlling what Sister Carol Keenan of the Catholic Health Association does. So that's one point. It's not always the bishops. The entities that the bishops control, those are the ones that were exempted from the beginning. So that's one point. The second point is, in America, you have a right to run a hierarchical church, as well as a democratic church. And there have always been some tensions asserted between that nature of Catholicism and the American individualist democratic ethos. And we're still facing those now, but the Supreme Court has said over and over again that you have the right to run churches where a small group of leaders make the decisions, and the First Amendment guarantees that.
Anybody else on the panel want to address this?
I mean, I do think you have to think it's problematic for a court or the government to tell the Catholic Church what it is.
Yes.
And that's the problem. I mean, that's the problem. There's another line of cases which I won't go into to avoid Alan's principle here of not letting the thing go on too much into the weeds. But I think one of the basic First Amendment principles you have to have is that the government can't tell the Catholic Church what it is and what it believes in.
Well, I think I want to. I mean, do you want to quickly?
I didn't hear.
Bell becomes Catholic Bell. I own a Taco Bell, and I change the name to Catholic Bell, and I say I'm the CEO.
This is the problem with exemptions. I mean, I think one of the problems with exemptions is you always have the question of religiosity. Is it a religion or not? You also always have the question of sincerity. And I think one of the reasons why the exemptions died under Smith, that was Stevens' rationale anyway, is he thinks the government shouldn't look into those questions. You're going to look into those questions, which you need to for an exemptions. The end result is you don't have the exemptions. But I think once you start accommodating religious belief, it's really hard to try to tell a religion. You might do some level of sincerity test if you can, and then there's a whole case dealing with that. But you know, how do you prove if somebody's religious or not, and how do you take it at face value? But that kind of inquiry is a fairly dangerous inquiry.
Well, venturing into danger, I guess I would say that I agree with Bill, it's complex, but I would tend to, at least let's just talk about the contraception mandate. To me, it's one thing when you're talking about a nonprofit, religious institution, and once you start getting into the profit-making, entities like a Taco Bell, I become much less willing to say that those should be accommodated as an institution. So it's not that they never can be, but I think that there is, in the law, there has been some tradition of being much more accommodating of the notion that a nonprofit institution is dedicated around propagating certain religious principles, and more skeptical of the notion of for-profit entities doing so like a chain like Taco Bell. And I think, so I'd try to venture down that avenue.
Great. Let's get another question. We have, sorry, sir. Yes, you. Oh, sorry.
I had a question regarding the comment that race was fundamentally different. Assuming that you're not looking into the validity of religious beliefs, but simply into the sincerity, under the religion exemption doctrine, why shouldn't a church that has sincerely held beliefs that it cannot accommodate interracial couples, why shouldn't they get an exemption from the law? Isn't the government choosing between religions in that case if it awards exemptions to some and not to others?
Anybody?
That one's not to me. Yeah.
Well, you would be saying, not that there's excuse me, I think everybody on the panel, well, I don't speak for everybody. The likelihood, you would not be saying in most cases that the objection by the racist group is insincere, although a lot of them are, let's be real. But you would be saying that there's a compelling interest because of the history of race discrimination and the nature of race discrimination. So anytime you apply a general standard like compelling interest and get different results in different cases, you could call that discrimination between religions. Justice Stevens called it that. That's why he was against the exemptions regime. Justice Blackmun, on the other hand, defended it by saying, this is the way in which we apply a general standard to the facts of different cases and try to make room, as much room for religions as we can. We're going to make a distinction between a group that uses drugs in a way that causes widespread trafficking and a group that doesn't do that. And is that discriminating between religions? Well, not in an impermissible way if you're applying a general standard that's meant to protect freedom as best we can under the circumstances of the case.
So a very brief observation and then the question. The brief observation about the notice point that I think is important is, I agree with you, Melissa, it'd be great to have notice, but not just to avoid the problems that the recipients of the service face, but also to allow all the people who believe in equality to say, if you're not providing morning after pills, then I don't shop in your pharmacy. If you don't allow gay couples to get married at your facility, then I won't get married there either. And so I think there is an important role for people to recognize whether somebody has conscience or not, other people have consciences that go the other way.
Absolutely.
The question I wanted to ask is the following, which is I went back and read the brief that the Catholic bishops filed in Loving against Virginia. Oh. And they made an argument in Loving against Virginia that they should be exempted from Virginia's ban on interracial marriages because their religion said that people of opposite races should be entitled to the sacrament of marriage in their church. And so I wonder whether it isn't worth our making the argument to the groups that want to make conscientious objections on their side. Okay, if that's your view, then Mississippi should have to have a conscientious objection to the Methodist Church if it wants to perform marriages and have those marriages recognized by the state. That is, this is maybe another version of Bill's point, which is if it's goose, if it's sauce for the goose, it's sauce for the gander as well. And one thing that interests me is we now assume that these are all conservative and that there isn't a kind of liberal conscientious objection on the other side that ought to be pushed either to create equality or to drive people towards Bill's position, which is this is unworkable, there shouldn't be exemptions for anyone.
Well, I absolutely appreciate your point, your first point about the, the way in which notice can work and the purposes that it can serve. I agree with you entirely. On your last point, I'm not sure I'm entirely clear on it, but it seemed to me that it related to a kind of weird situation we have now where marriage is all messed up between church and state, where we've got religious people, ministers saying at the end of a ceremony, by the authority invested in me by the state of X, I now pronounce you, which always sounds very weird to me because I think the authority invested in them is not by the state but by another higher power. So it seems to me that it would be, in an ideal world, we would disaggregate those things and not have the religious community marrying and blessing who it will marry and bless, and the state having civil marriage and marrying and saying, and some people would have both, and some people would only have one, and religious communities would decide to bless different things and do it different ways. But that's just an ideal, and that I know that's not happening, but I thought I would just say that. Somebody who got the question, I'm not sure I understood the full question, if anybody else wants to come in on that.
Do I hear you, Pam, as saying that if your faith says that you should be able, like I think it was the United Church of Christ that did those powerful ads on marriage for same-sex couples, that the United Church of Christ should be able today to argue for a conscientious objection to a law that prohibits them from recognizing
that's
marriage,
what the Catholic
same-sex
Church
marriages.
argued. The Southern Catholic bishops filed a brief in Loving that said the reason that the Virginia law is unconstitutional is in part it violates our First Amendment rights. Now, I have a sense of where Bill would come down on this, which is you don't have a First Amendment right to any of this, so don't worry about it. But if that's the position, then it seems to me that one of the things that liberals ought to be pressing now is an argument that says, okay, if you're going to make these arguments for exemption from generally applicable law, then if the state of Mississippi wants to say no legal recognition for same-sex couples, then if you've got a religion that's going to recognize that you are in the same position as opposite-sex couples, Mississippi should have to comply with that as well.
I understand your argument now, and I believe people are making that argument today. There are groups that are making that exact argument that you suggest, now that I understand your argument. So that is happening, maybe not to the extent that you would like to see that expand, but it is, some are raising those arguments now. I believe Americans United for Separation of Church and State makes that kind of argument. I'm looking at Dina Scheer out there because she might be able to help with that, but I won't put her on the spot.
I'm sympathetic to that idea, and I'm sympathetic to that device of showing that these are not only conservative objections. If you said that, I don't know this question back to you, but if you said that, would you also have to say that the public official who refuses to give a marriage license therefore has a free exercise right to refuse it? Because you've now extended to the act of the clergyman as an official actor of the state pronouncing a marriage valid. That's the line that I assume the Supreme Court wouldn't have crossed in Loving and wouldn't cross now with a Methodist objection. Whether it should cross it or not, I don't know. But if it did, then I think you'd also have to say that the clerk in New York who says, I'm not going to do any of these, should have a right too. And I'm kind of negative about the clerk saying that. So I don't know where that leaves us.
At the end of the time?
No, not yet.
No, I'm okay.
Sir.
More questions? More questions? Sorry.
Poor Louise. She's representing an institution that was founded in 1920 by Roger Baldwin on conscientious objection to a war. And this whole piece of America and the right to follow one's own conscience is so part of all of what we believe as a nation and as a culture that this has got to be really hard. But in the final analysis, I take the position that sexual orientation is the same immutable part of who you are as a human being as race or any other. And I could argue that while whether or not it was worse to have be pilloried on a stake in Wyoming or dragged behind a car in Texas because of, in one case, your sexual orientation and the other your race is irrelevant. I'm not going to argue which is worse. But a lot of the questions around this as to the options in order to allow people to exercise their conscience have been made by people who I think have never lived in a rural area. That whether or not getting contraception from the pharmacist A or pharmacist B in the same pharmacy may be a nice distinction to make in that pharmacy itself. It's just not possible in lots and lots of America. And the distinction between whether or not a pharmacy has gotten a license to practice a public service or a church has gotten a license to open the facility because it now has a sprinkler system and it's a place of public assembly. I think you can't make these kinds of distinctions. I think you have to make a decision. And I think that your decision is going to be based on values, and the law is created by values. I'm an atheist. I don't think that that Melissa's deity is blessing my wedding. But I think my wedding is a construct of the government, by definition. I am not taking a position here. I'm asking a question. Can all of you draw bright lines here? Can you actually make distinctions? Can you make that decision based on circumstance, or do you have to make it on principle?
Great question, okay? I mean, because the issue, I've been somewhat facetiously defending the no exemption position, but it's a hard one. And it's a hard, I mean, you know, I was asked time and time again after Smith, does that mean if a town bans alcohol, you can't use alcohol for sacraments? Yeah, pow. You know, does that mean Jehovah's Witnesses have to have their pictures on their driver's license? Yeah. I mean, it's a hard position to take. But the other side is equally hard because of the questions of figuring out what sincerity is, the question of figuring out religiosity is, the questions of why you would prefer a religious-based ideology over a non-religious-based ideology. These are tough questions. I will give the most religious answer in favor of rejecting the exemption I've ever heard. I gave a talk once, and the theologian Stanley Hauerwas was my commentator. He came over to me, and he said, "You're Mr. Marshall, right?" And I said, "Yeah." He said, "Good. I'm going to agree with you." And I said, "Phew, wow, this is terrific. The commentator's not going to be that bad." So Stanley Hauerwas gets up there, and I gave my comment, and I gave my argument in favor of why we shouldn't recognize the free exercise exemption. And he got up there, and his response was, "I agree with him. People who believe in religion have to know that the state is always the enemy." And they shouldn't be accommodated for that reason, because it's a test of their faith to not risk disobeying the law. So I crawled into a corner, but he made a valid point. It's a hard position to take. It does seem to me that when you're taking a look at the overall balance at stake and the problems at stake and the, you know, conscientious objection to war, I believe in conscientious objection to war. I believe in the Selective Service Act. I wouldn't get rid of that exemption. But think about it. Every person who doesn't go, somebody else does.
Yes, exactly.
There's a lot of price that's paid for those kinds of exemptions.
I was just gonna, I think for institutions, it's for me as a sort of a representative of ACLU, it's easier. When you get down to individuals and you go from the person who wants to object to performing the death penalty to the person who wants to object to providing the individual pharmacist in other contexts, I find the individuals harder than the institutions. But institutions, I feel like that one's a lot easier.
I had.
Thank you. One of the issues that I haven't heard much discussion, if any discussion about today, is the end-of-life implications. And your comment about notice, in every state advance directive law, there is a refusal clause, a conscience clause. We have a federal law, Patient Self-Determination Act, which requires hospitals and nursing homes and entities that receive Medicaid and Medicare to provide notice and to explain what their institutional objections would be and the distinction between the institutional and individual physicians on staff. And they're supposed to have written policies that explain that. That notice is not necessarily put on their website. It's not necessarily given to the community.
Wow.
You may not know about it until you show up in the emergency room and find out whether or not your advance directive will be honored. And I guess I would encourage all of you who care about this issue to be aware of it. And when you do have hospital mergers, such as in Waterbury, Connecticut right now and other states, that you be aware of the end-of-life implications as well.
I really appreciate that, and that specific information is great, and boy, that really needs fixing. Let me put in one little plug here for a report I wrote with Bill Galston and Brookings on, I can't remember the name of it, but it's about conscience and access to health care. And we brought a group of people who really disagree about these issues, but brought them together. And one of the things that the group could agree about was this idea of getting more notice on the web, getting more disclosures and all this stuff on the web. As you suggest, this is extremely hard to do. I question, all these positions, and I think you make some excellent points. I do think there are certain areas where, while we're trying to sort through the big ticket item questions, we can do better on disclosure and notice and make some headway where there is common ground and fix ridiculous things like that not being on the web.
We have 5 minutes. I want to take one more question, sir.
The point made earlier about the government funding got me to thinking about the opposite side, which is paying pursuant to a government mandate. And so if you view the contraceptive problem as not requiring anybody in a religious organization like Georgetown University to actually perform abortions or provide contraceptive services, but look at it as a payment of money, it seems to me that that's kind of like the conscientious objectors during the war who could refuse to serve in the military, but they couldn't refuse to hold back part of their tax payments because they didn't believe in the war. And so I wonder what the panel thinks about the money payment different from the service providing as at least one part of slicing and dicing the problem.
All right. I guess I'm no healthcare expert, but what I've been told is, and I think what the administration has said, is that adding this contraception coverage actually doesn't add cost for the provider because it's more costly to pay for births than it is to pay for contraception. But I guess I would say that the burden question, I feel very strongly that the women who work for objecting employers, there is some cost to them of a policy that would allow religious groups to object, and that the state ought to find a way to ensure that the women who work for objecting employers can access the contraceptive coverage on the same basis as if they worked for a non-objecting employer. I guess I see that's where the cost comes in that needs to be attended to in terms of the cost to the women who work for objecting employers.
I hear you as making a different argument, making an argument as to whether or not there's a burden on the exercise of religion, given that this is more removed than it would be if you provided the contraception. You're just
my
paying
point
for
was
insurance.
that the organization should not be able to object on the grounds it is paying money which is a different kind of objection from having to actually perform the services. I mean, if it's not actually costing them any money, then they don't have any objection at all.
Well, I think their objection is both paying for and providing, seeming to endorse a benefit that they object to for religious reasons, to say, here is your health plan, and we're Catholics and we object to contraceptive coverage, but here's your health plan that covers that. Now, we can debate whether that's true. I'm articulating their objection. Does that make sense?
Yeah.
Okay.
I understand.
Yeah.
These are all kinds. The way the Catholics put it is these are questions about cooperation with evil and how close the cooperation with evil is, and so on. And you could I think equate the two, but they have a reasonable position that there's a difference between being one of millions of taxpayers who contributes to a policy and being the employer who's providing for 100, 200 employees and writing in a policy that you may have to administer and so on. You're just much more involved. And generally in the area of conscience, we give some deference to the scope of the objector's understanding of the faith.
I think that is pretty much brings us to the end. I'm going to read something that has been provided for me. There are a number of events scheduled immediately following this session, including a book signing with Peter Edelman and Linda Greenhouse, as well as the silent auction taking place on the Capitol Terrace and Upper Lobby. There are also 2 informal breakout sessions, ALICE, a progressive response to ALEC, in the South American room, and National Popular Vote in the Federal room. Beginning at 6 p.m., we invite you to join us in the Presidential Ballroom for remarks by U.S. Supreme Court Justice Ruth Bader Ginsburg. The day will conclude with a reception in the Congressional and Senate rooms at 6:30 p.m. with featured remarks given by Richard Cordray, Director of the U.S. Consumer Financial Protection Bureau. Volunteers will be on site to help direct you to these locations. Thank you very much for coming.